for your patience. This has been an interesting morning so far. I don't know about you guys. Some days are just like this.
Okay, we're good.
Okay, let's get started. Welcome, everybody. Thank you so much for joining us. Today is our third class at Get Closed, Get Paid. Today we're going to talk about Senate Bill 264 and working with foreign customers. As always, you can follow us on Instagram at getclosed.getpaid. My name is Erin Miller. I'm a real estate attorney, and I've got the lovely Kristen Jaiven here as well. We are proud to put on these presentations for real estate agents and brokers. I typically focus on the closing transactional side of real estate, and Kristen offers perspective from the Brokers Council. She represents agents and brokers in Florida. So we are always happy to share what's going on in the real estate market. And today our topic is, of course, SB-264 and working with foreign customers. And let's get some housekeeping notes out of the way. This is an educational presentation. This does not create an attorney-client relationship between the attendees and either of our firms or the attorneys. Of course, if you'd like specific legal advice, please engage counsel. You're welcome to reach out to Kristen or me if it's within our practice area. If it's not within our practice area, we've got a lot of attorneys that we have connections with across the state of Florida that we can point you towards. Also, we do want to remind you that this is a forum for open discussion and sharing ideas, but we are not going to participate in anti-competitive behaviors or risk violating antitrust laws. And so just take precautions, of course, with that. And I think there was another disclaimer, but I'm not sure what it is. So I think we're good to go. All right, today our agenda, we're going to talk about, again, Senate Bill 264, what it does, what we need to know in the real estate industry, and what we need to say or not say when we're dealing with customers. We're going to talk about the affidavit requirements, and then we'll talk a little bit about working with foreign sellers and FIRPTA. And then we'll have an open discussion at the end. So if you have any questions, just feel free to put them in the chat and we'll discuss all of the questions and presentation. All right, so you've heard about Senate Bill 264. We had a lot of discussion back in July when the bill became effective, when it deals with who can purchase real property here in the state of Florida. It restricts ownership by certain foreign principals from certain countries of purchasing certain real property in Florida. So it is not an anti-international customer law, but it does restrict ownership by certain foreign persons in the state of Florida. And there are sort of two major aspects of the law. One is that it requires buyers who purchase real property in Florida after July 1st, 2023, to sign an affidavit at closing stating that they are either not one of the persons who are restricted from purchasing property here in rural Florida, or that perhaps they do fall into the category of certain foreign persons that the law restricts, but otherwise there's an exemption for either the type of property that they're purchasing, or maybe they fit into a category of an exemption. The other requires certain property owners who fall into the certain foreign owners category, certain foreign principals, to register their property with the Department of Commerce. And I'll provide you a copy of that link as well. So why do we care? Well, we care from a transactional and closing agent standpoint. Is our buyers, all buyers, cash buyers, loan buyers, are now going to be asked to sign an affidavit from the closing agent at closing, indicating that they're authorized to purchase real property here in Florida. And if you are typically working with cash buyers prior to July 1st of 2023, your buyers could sign their settlement statement electronically, sign their closing agreements electronically, and submit everything for closing, and everything was great. Buyers never had to appear in an office to have any documents notarized because it was a cash transaction. Now, even our cash buyers are being asked to sign an affidavit, which needs to be executed in the presence of a notary and remitted to the closing agent. Now, the affidavit is intended to be prepared by the Florida Real Estate Commission, and we'll talk about their process for preparing the affidavit. But for now, just know that closing agents are using affidavits that are prepared by their underwriters for use in real estate transactions. So this doesn't mean that real estate agents need to be providing an affidavit. Please don't, actually. Real estate agents don't prepare an affidavit, don't seek an affidavit out, but you can let your client know that they may be asked at closing to sign an affidavit indicating that they're authorized to purchase real property here in Florida. Closing agents will get those affidavits executed, but again, you may want to prep your client because they may have to go to, all buyers, no matter where they're from, may have to go to a notary, may have to go to the closing agent's office, and they may need to use remote online notarization to verify their identity and execute the affidavit at closing. And so that's an additional step that closing agents are having to go through to help our customers comply with the law. And for our buyers, there are criminal and sellers, there are criminal penalties for knowingly selling or buying in violation of the law. So while we as real estate agents are not going to give legal advice to our customers, we want to point out the language in the contract that folks need to be aware of, and then be able to point them to legal counsel if they have any questions as to whether they fall into the category of certain foreign principles, or whether this property, doesn't meet the criteria where the buyer would be authorized to purchase it. So that is our brief little overview. I'm going to go to, so what can we say? And so Kristen and I both sit on the Florida Realtors Joint Realtor Attorney Committee. Oh, that was the next disclaimer. Okay, so we sit on a bunch of committees. We serve on a bunch of committees, and though we speak about some of the work of the committees that is published, we do not speak on behalf, when we're talking as on behalf of Get Closed, Get Paid. We are not speaking for Florida Realtors. We're not speaking for the Florida Bar. We do not, any of the boards that we do work for, we don't speak on their behalf. These are just our opinions in order of talking about our experiences. I'm going to add that to our disclaimer language. Okay, so this language in the box, we call it in the box language, the warning language. This language was put into the FAR Bar sales contracts starting effective July 1st, 2023. So if you're working with the FAR Bar contract, make sure you're using the version that ends in the letter X, because that is the most up-to-date version of the Florida Realtors Florida Bar contract. I guess it does, 6X. So the revision came out in July of 2023, revision 6X of the Florida Realtors Florida Bar contract. You'll know that it is the correct version because right above the signature lines, you're going to see what I call the big box language in bold. It is a notification to our buyers and our sellers that this law exists and it applies to certain foreign principles, and that it puts the buyer on notice that at closing they will need to sign an affidavit which complies with the requirements of the act. So we'll go through it real quickly. So the conveyance to foreign buyers notice. It notifies the parties that it limits and regulates the sale, purchase, and ownership of certain Florida properties by certain buyers who are associated with a foreign country of concern, including the People's Republic of China, the Russian Federation, the Islamic Republic of Iran, the Democratic People's Republic of Korea, the Republic of Cuba, and the Venezuelan regime of Nicolas Maduro, or the Syrian Arab Republic. And so we also put in big bold language that it is a crime to buy or knowingly sell property in violation of the act, and of course gives the parties the notice that they should seek legal counsel if they have any questions, if a buyer has questions as to whether they can purchase a property, and the seller should seek counsel not from their real estate agent, but from an attorney who's licensed in Florida as to whether the seller can sell a particular piece of property to a purchaser. And I will say that this language is pretty fair. It's pretty, here is the facts. This law exists. The parties are going to need to comply with the law. And some folks will say, well, what does this mean for this, the deposit? If the buyer is not authorized to purchase the property, what does this mean as far as the sales? And so what I suggest, if you have a buyer that you're working with and they review the sales contract, you point out the big box language, and you can't give them advice as to whether the law applies to them or not. Have them seek counsel prior to going under contract. Again, if you've got a buyer, you typically work with them for a few weeks, months, maybe years before you actually go under contract. Have that discussion with them. Have them seek counsel early on to see whether whether they are able to purchase real property. But you're not going to give them legal advice. You're not going to go through an analysis to determine whether they can actually purchase. The other challenge, I suppose. So let's say a buyer enters into a contract and they find out prior to closing that they cannot sign this affidavit because either they fall into the category of folks who cannot purchase real property, and it would be illegal for them to purchase a property, and it would be illegal for the seller to sell the real property. Kristen, what do you think? Do you think that if in this situation, if a buyer finds out later that they actually can't purchase the real property, they're out of their due diligence period, do you think that the buyer would be able to get their deposit back, or do you think they would be stuck?
So this is something I think that we've debated pretty heavily when we were coming up with the language in the contract. Right now, there's not guidance in the statute that says what happens in this situation. There's also, to my knowledge, there hasn't been a case where it was litigated. So until one of those two things happen, it's going to be arguments made by two attorneys if this went to a lawsuit. And I think they would both have pretty strong arguments. From one respect, the buyer, I believe, would, if I was representing the buyer, I would argue impossibility of performance under the contract because it's illegal for them to proceed under the contract. If I was a seller, I would argue you should have known that when you signed, and now I have damages because my property has been off the market for 60 days, and you saw the disclosure at the beginning, and now you know. That is something that's going to be flushed out between two lawyers and the facts of the case, and ultimately decided probably by a judge. But I haven't seen it happen yet. I would love to see some sort of structure around this, but we don't have it yet. So in the meantime, best bet is to make sure at the time the purchase contract is executed, the parties, at least the buyer, I should say, knows of the rules. And I would caution not to enter into a purchase agreement until they know whether or not they can sell, especially if there's a question about it. A lot of questions I've received is, well, how do we know if it's a property that's subject to the act because of its proximity to critical infrastructure? Based on our understanding and some of the maps we've been given to look at, critical infrastructure is not always publicly available because it's critical and it's hidden for a purpose. But what is available, what we do know, things like major airports and ports and military bases, things of that sort, water treatment plants, it covers most of Florida. So if there's a question whether the buyer can buy property subject to the act, I think you have to address it. And you've got to start looking at the exceptions and determining if the property is subject. When this law is brand new, I mean, this just came out in July. I guess not brand new, it's a few months old. The affidavits, the rulemaking hasn't even finished yet. We'll provide do you want me to provide an update on that, or do we have a, we have a slide.
I would love it.
Okay.
Okay, please.
So there is a rulemaking. FREC started rulemaking. They were required under the statute. So when the law passed, it said, FREC, you need to go create an affidavit. You need to go create rules. Also, it was DOE? DOE, right?
Yes, but I think it's now it's Department of Commerce, but I'm not entirely positive. I have a
Department of Commerce.
Site, yeah.
Okay, so Department of Commerce and FREC, you need to go make rules to implement this statute. So, if we go back to legislation 101, like the old Schoolhouse Rock, there's the statute, it gets implemented by the legislators. And then from there, certain administrative bodies implement rules. So we're in that rulemaking phase. There's been a number of meetings by FREC. There was a public meeting, I believe it was about a month ago, where we looked at what the form affidavit was going to look like, and there was an opportunity to make comments. And now there's a published affidavit, and anyone can make a comment on the published affidavit for 21 days from November 1st. So we've got about a week left. So November 22nd, that will be the end of the comment period for the forms. And then we should have an actual official form, and we should have official rules. At some time to follow. But while we're in this in-between stage, what has happened is that various title underwriters and other industry folks have just created a temporary form to get us past this moment, because the law went into effect before the rules went into effect. So we're waiting for FREC to announce that, but it's in the works. If you'd like to make a comment, that's the link. But yeah,
in the link, it also has, and this is a link to the Florida Realtors article that has some of the proposed language that the affidavit would say. But essentially, it is this person am either considered a foreign person under the Act or I'm not considered a foreign person under the Act and authorized to purchase real property in Florida, or I am a foreign person under the Act, but I'm otherwise exempt from prohibition of purchasing the property. So essentially, that is the language that the current affidavits that have been circulated through our title and closing agents offices, that's what it says now. But I think the rule will also clarify some of the questions that we had in sort of language. So the law says at the time of purchase, buyers shall provide the
I guess that
affidavit.
email went out to a lot of people, a lot of big head people. So they've been calling me all morning about that situation.
Oh, okay. Thank you. So at the time of purchase, buyers are required to provide the affidavit. And so there was a question, is that at the time of purchase, meaning entering into a sales contract, or at the time of closing the transaction? And so I think the clarification will be that it will occur at the time of closing, which makes sense for practical purposes. Buyers, will, among their closing documents, have the affidavit executed. So the other part of the requirement of this new law was for certain current property owners who fall into the category of certain foreign principals, requiring to register their properties. And so there is now a Secure Florida portal where property owners can go and identify if their property needs to be recorded, and use the floridacommerce.mysite.com website to be able to actually start the process of reporting their ownership of the property. In fact, this article just came out on Florida Realtors as well regarding the website. So we can send you our slides afterwards, so you can hop into those links and find out more information. But yeah, so we are in limbo a little bit, but we have closing agents are doing the best we can to make sure that we can comply with the law. I will say one of the challenges we've had is getting realtors to understand that the law requiring the affidavit at closing applies to all buyers. So it doesn't just apply to foreign buyers. And I will say anecdotally, we had someone who we had asked their clients, let them know that we are going to need this affidavit executed at closing. We'd be happy to facilitate the notarization. And we received a call from the real estate agent who was very concerned that we were perhaps singling out his client because he had a foreign looking last name. And we're like, no. This affidavit requirement applies to everybody. No matter who's purchasing the property, we're going to ask every single buyer if to sign this affidavit, because we're helping our clients comply with the law. So just for agents to know that every buyer is going to be asked this question, and really, and Kristen, you can talk about this, really put the onus on the closing agent to ask some of these questions, because we don't want to have our agents sort of creep into violating fair housing laws. So this is sort of a good segue into Kristen. I want you to talk a little bit about sort of where the lawsuit that was filed just after this law came out. And so what we want to help agents do is make sure that they're letting their clients know that this law exists, and that between the real estate agents and the closing agents, we're going to help them comply with the law, but also want agents to be very, very careful about the language they use and their practices to avoid violating fair housing. And I think that was one of the big challenges when the language was being created to put in the sales contracts. We didn't want to encourage real estate agents to ask questions about the national origin of their customers to find out whether they can, sign an affidavit and that kind of thing. So, Kristen, tell me about what's going on with the current lawsuit.
So yeah, so just the fair housing rules, how when this first came out, how I've kind of explained this is that you have this law that came out July 1st. It's a Florida law, so this came out in the state of Florida. And simultaneously, you have a federal law, the Fair Housing Act, which all real estate agents are required to follow. There's lots of implications if you violate fair housing, including Florida licensing issues. And they appear on their face to conflict. There's a lot of people who agree that there's a conflict between the Fair Housing Act and the implementation of this law. And because of that, a lawsuit was immediately filed in the state of Florida. I believe it came out of the Orlando area. It was brought on behalf of both sellers and brokers. And it's the Shen case. And that case sued a variety of parties, including the Commissioner of Agriculture, and said this law is illegal based on various reasons, but it violates fair housing and other laws that protect against discrimination. That law went forward to an injunction hearing. An injunction is a legal remedy that says, yes, we're going to hear the case, but on its face, there's enough evidence to show that this new law cannot be implemented. It's illegal. So we're going to stop the implementation and we're going to pause it. We're going to pause the enforcement of the new law, which would be the Florida law, until we can hear the full case and the full allegations, because we know the legal process takes a long time. The injunction was not granted by the court. So the ultimate the result of that is that the law went forward and it's now out there while the lawsuit continues to move forward. So what that does is it puts realtors in a position where they have to make sure their customers don't violate this law, because there's criminal ramifications. There's also potential to have forfeiture of property. So major implications for their customers that they have to maneuver while simultaneously not violating the Fair Housing Act. And it feels at times almost impossible to comply with both of these at the same time, because you're getting contradictory information, but the agent kind of has to straddle both at the moment. To stay around that issue, my recommendation, kind of like Erin always says, because she's got to follow fair housing too, is that you treat all buyers the exact same, no matter who they are or what any type of presumptions you may have. You shouldn't be making any presumptions. Every buyer should be warned, should be given the disclosure, which is now baked into your FAR contract, so you have it. And every buyer should be told there's going to be a requirement of signing an affidavit. And then you don't make any statement as to whether or not the law applies. If you can say something and you should say this to all buyers, not just the buyers you think it might apply to. You got to treat everyone the exact same.
Yeah.
Buyer, if you have any, this is a disclosure. This is something a law in the state of Florida that has to be followed. If you have any concerns about this, let me know now so I can get you referred to counsel. There's a saying in realtor representation that you should always be the source of the source. What that means, and this goes true for everything, you should never be the direct source of information. You should always be directing your clients to a third-party source. And that's true for a lot of things. You know, if someone asks you information about a property, don't rely on what I say. You should rely on what the property appraiser says, things like that. And the same thing here. You want to say, you want to limit your conversations to this is what's out there. This is what the law is. This is what's required to be complied with. And I can't give any information as to whether it applies or not. And that's to avoid fair housing issues while this gets worked out. Once the lawsuit goes through, if we have an update, we will provide it. But as of right now, we're living with both being out there. I did just want to briefly mention, for anyone who's familiar with the vacant land scams, that's been going on probably a few years. The vacant land scams is basically these scammers look up vacant land that's owned by out-of-state or foreign owners, and then they try to basically file fraudulent deeds and move the property and then try to sell it and collect the proceeds. This scam has been going on for a while. There's lots of ways county appraisers and things like that have tried to, or county clerks have tried to prevent these fraudulent transfers. There's different reporting. Some counties have reporting requirements now where they give you a little notice if your property was transferred without your knowledge, things like that. But the new scam, the new twist on that scam that I just discovered last week is that now foreign buyers are calling and saying, or sorry, not foreign buyers, the scammers are calling real estate agents and saying, I am a foreign buyer and I have a requirement to relinquish my property under SB-264. So can you effectuate the transfer? And it's still the same scam, but they're giving this justification that it's a transfer related to SB-264. And I just ran into this last week and I was like, the scammers are always like 2 steps ahead. So you got to kind of stay behind, but just be aware of that. You should always be wary of transfers that just people who call out of the blue and they don't have good information about the property. If you have that little tickle, you know to start asking really a lot of questions. Okay, there's a question from Melissa. Can a realtor get criminally charged if they do not know if the seller or buyer signed the contract and indeed cannot purchase or sell? This is a good question that is not directly answered by the rules in their current state. There wasn't a clear answer. There's some vague language that talks about being associated. And I think there could be a fact scenario where the agent, if they were knowingly involved, could be brought in under that. But directly on its face, there's no direct potential liability baked into a licensee. But I think you could be brought in if the licensee was knowingly involved. So that's one of the areas that was gray and not completely fleshed out in the statute. But that's why you have these disclosures. These disclosures and the affidavit, it protects sellers too, because if there's an affidavit buyer saying I'm allowed under penalty and perjury that I can buy this property, then the seller can rely on that. Obviously, if the seller knows other information and stuff like that, then that's a problem. But yeah, you want to make sure you're using the current FAR contract and that you're working with title companies that use the affidavit. I'm sure there's title companies out there that aren't using this affidavit, which is, I think, a problem. So make sure your title companies are using the affidavit. Make sure you're using the FAR contract with the disclosure. And then if you actually have information about this and you think it might be a concern, make sure you document that you directed them over to counsel to get review of this.
Yeah. Yeah.
Hopefully that answers the question.
So that's a good point, Kristen. So there is a safe harbor for closing agents who do not know if a particular transaction violates the law, but if they know and they too are facilitating the transaction, they say, oh, we know that this buyer's foreign, we're not going to give them the affidavit because we know that they're not going to be able to sign it, and we just either proceed the transaction and close. The title company closing agents could be held liable. I have heard, but I don't have proof, but I've heard that there's some title companies who say, listen, we have a safe harbor. We're not even going to get involved with the buyer affidavit whatsoever. We're not even going to, yeah, that was my take too, Kristen. I don't think that that's the right approach. I think the responsible thing, of course, is that we as a closing agent are going to do everything that we can to help our customers comply with the law. We're not going, a title company is not going to give legal advice, but they're going to provide the forms that their underwriters give, to be able to facilitate the transaction. I'm going to go back a half a step. So you're talking about the vacant land scam. So just so you know, if we, or most of our underwriters now require us in the event of a vacant land sale to send a letter, especially if the owner is foreign or there's a foreign, tax address, to send a letter, let's say by FedEx, with a notification to the property owner saying, hey, thank you for reaching out to so-and-so realtor, so-and-so title company, so-and-so law firm to close the real estate transaction for the sale of your vacant land. In order to avoid fraud or to confirm that you are who you say you are and you are intending to sell the property, please give us a call at our office with a particular code. And let's say our code is, get closed, get paid is our code. Right, and we have them call our office to confirm, because what we're doing is sending the letter to the tax address that's on file. We're not sending it to the property address, we're sending it to wherever that property owner receives the tax bill. So if they are in Canada, we're sending the letter to Canada and expecting the property owner from Canada to call our office to confirm that, yes, in fact, they did engage so-and-so real estate agent and broker to sell their property. Or the alternative is they call and say, no, I have no idea who this agent is. I did not intend to sell this property. Thank you for letting me know. And then of course we let the agent know, and they can appropriately, alert the authorities. But yeah, that's an extra step that we have to do on the title side to make sure that the properties are not being sold out from under the rightful owners. So just another quick note on this particular side. So Miami Realtors has a good sort of database of information on the Senate bills. So they do have some resources that you can look at, information that you can provide to your listeners. All right, is there anything else on SB-264? I think we will provide an update as soon as we get one. Hopefully the rules will come out soon. And okay, so we're going to talk about a little bit about working with foreign customers, so other considerations. So we know this has nothing to do with Senate Bill 264, but I thought it tied in to our theme of working with foreign customers. When we're dealing with FERPDA, we do have a good FERPDA handout recap, and I'm happy to send around. But essentially just some highlights about FERPDA. It is a requirement for withholding of 15% of the purchase price if the seller is a foreign person. A withholding is not a tax itself. A withholding is a requirement that funds be withheld by the purchaser and remitted to the IRS as an incentive for the foreign seller to file their income taxes for the year of closing. So I said a few things there that hopefully perked up your ears a little bit. So it's a requirement that a purchaser of real property actually withholds the funds and remit it to the IRS. And you say, well, the buyers never do that. That's the closing agent's job. Right. So the contracts allow the closing agent to serve on behalf of the buyer or the seller to withhold on the settlement statement 15% of the purchase price, and they will take over, take the responsibility of remitting the funds to the IRS. I've had agents who say, well, I don't work with a lot of foreign customers, so this doesn't apply to me. Well, you might not know at the beginning of your transaction, when you have the buyer of the transaction, that the property, that they're purchasing property from a foreign seller. But you may find out throughout the course of the transaction, because the closing agent said, hey, we're going to have to include withholding. At closing, this is going to be, the amount of money that's on the settlement statement, blah, blah, blah. Why would your buyer care? Because the IRS is going to look to the buyer to make sure that withholding took place and make sure that the funds were sent to the IRS. So your buyer could say, well, FERPDA only applies to the seller. It's the seller's money. I don't really care. But the responsibility in the IRS's eyes, the responsibility lies with the purchaser. And the purchaser is hoping and praying that they're working with a title company or closing agent that knows what they're doing, that they've done FERPDA filings before, and that they actually do remit the funds to the IRS. Because if they don't, if the title company drops the ball, if the law firm drops the ball and does not remit the funds, the IRS is going to look back to the purchaser to provide the withholding amount and interest and penalties. So we don't want that to happen to our purchasers. So that's the moral story, of course, is work with a closing agent who knows what they're doing, who's worked with foreign customers before, who is comfortable making those appropriate filings. And for practical purposes, our FERPDA, or standard M of the FARBA contract, has the form or language that says seller and buyer agree to cooperate with the closing agent. 15% of the purchase price is going to be withheld unless an exemption applies. So the exemption that could apply is if the seller is a citizen or a otherwise exempt under the law. If you have the listing and you're working with a foreign seller, you want to ask them at the very beginning of the transaction. They say, hey, I am out of country. And you say, great. FERPDA applies to every transaction. So either if you have a U.S. Social Security number, not an ITIN, but a Social Security number, and you can provide it to the closing agent, then the 15% will not be required. Otherwise, you'll need to work with a CPA to get the U.S. tax ID number and ITIN and be able to make sure that the withholding takes place at closing. Now, there are options, and this is discussion for another day, to reduce that 15% withholding to 10% if the purchase price is between $300,000 and $1 million, and the buyer intends to use the property as a residence at least 50% of the time that the property is used by anyone within the first 2 years of ownership. That is a very lengthy explanation, but essentially if the property owner or their family intends to use the property as a residence more than they intend to use the property as a rental, they intend to reside in it longer than they intend to rent it within the first 2 years, then they may be able to sign a residency certification at closing that would allow a reduction from 15% withholding to a 10% withholding. And if the purchase price is $300,000 or less, then there would be zero withholding in the event the buyer intends to use the property as a residence and that kind of thing. So, and then just another note, when we're working with foreign customers, they're going to have to deal with notarization issues. So they're going to need a valid passport. Even if they're a cash buyer, they don't fall within the category of certain foreign principals that cannot purchase under 264, and they are overseas, they're going to need to work out the notarization and plan ahead because, again, those non-foreign buyer affidavits are required by everyone, even for our cash transactions. Our purchasers are going to need to sign those, so they may have to get an appointment at an embassy or have, let's say, a remote online notarization of that affidavit at closing. And then folks are sometimes surprised that if they're sending funds from international, from overseas or international banks, that it takes a little bit longer than our domestic banks do for the funds to arrive at closing. So you need to plan ahead to be able to deliver your funds to close. Anything else, Kristen, when we're dealing with foreign customers? Any other considerations? And do we have any questions?
Yeah, so I think sometimes I hear of agents saying that they get to the end of closing and the customers don't want to comply with the withholding, and then they want to cancel the deal. So have you ever had this happen?
I've had folks question it, but I have this hope that someday all of our customers will read the contract that they sign. That is my hope and my dream that folks are going to start reading the contract, and then and that they will see a standard M that says if you're a foreign person, then you're subject to FERPA withholding, and it is a requirement of the contract, and it's not something you can just back out of. But also, if I have a seller who is very concerned about having 15%, which is a huge chunk, right? 15% of the purchase price withheld, sent to the IRS until they file their taxes, there's two things that I would say. One is that that's not the tax itself. It is just withheld. The taxes themselves could be significantly lower than what is being withheld. And the IRS, once you file your tax return, the IRS will take what is due to them and release the balance. But also, there are ways to contract around certain things. So if you have a purchase price between the $300,000 and $1 million, and you want to reduce that withholding, you could make sure that the purchaser intends to use the property as a residence, so it's not an entity or something like that. But there are also there are plenty of options that CPAs have, not to avoid withholding, but perhaps they could apply for reduced withholding with a withholding certification, which allows the IRS to do the immediate calculation of what the taxes would be due. So, for example, let's say they've got a closing that's happening next week, and 15% of the purchase price needs to be withheld. And the seller's like, I don't want the money to be withheld for that long until I file my taxes in February, March, or April. I want the IRS to make the determination right away. Tell me what my taxes are, and I'll pay it and move forward. So what would happen is the closing agent could, rather than remit the entire 15% directly to the IRS, if the seller is working with a CPA to file what's called an 8288B, which is an application for reduced withholding, essentially is the request of the IRS calculate what their taxes would actually be for the seller's property. The closing agent could hold on to that 15%, hold it in escrow until they receive a response from the IRS that says you actually only owe $5,000. Please send us, the IRS, $5,000, and you're permitted to remit the rest of the $25,000 back to the seller. And that pre-COVID was happening much more quickly than a seller having to wait until they file their taxes. Now, I think you should ask a CPA for the current wait time, because I understand that they are no longer, 6 to 12 weeks. They may take a little bit longer. So strategically thinking, if I'm closing a transaction in the fourth quarter of the year, it may just make sense to have the funds withheld and then file your taxes in the first quarter of next year. But if you close in January, February of next year, and you don't want the money just to sit with the IRS until you file your taxes in 2025 for year 2024, then it may make sense to work with the CPA to file an application for reduced withholding that will essentially require that calculation by the IRS in a much shorter time frame. Again, that is, I stay out of the tax lane. That is a conversation that a seller should have with their CPA, but those are options that we as a closing agent could accept that would allow us to hold on to the funds until we get a response from the IRS rather than send the money to the IRS until the person has to file the taxes. But also, we don't make the law. We tell our clients, this is something that we all have to comply with, and, that's they usually accept it. They just don't want to be surprised. And nobody wants to be surprised at closing that they've got 15% less of their purchase price going immediately into their bank account. So I think we are at the end of this session of Get Closed, Get Paid. We really appreciate you guys joining us, and we would love to hear what topics you'd like to hear about in 2024. So send us an email at info@getclosedgetpaid.com, and of course follow us on Instagram at getclosed.getpaid. And our next topic for next month is MC with the holiday season. Yes, credits and rebates, which we'll get into a little bit about from the closing agent's perspective. We're going to talk like a tiny bit about rest, but we're also going to talk about maybe commission credits and rebates. It's a very tricky topic. We're going to talk about all things gift related.
Yes.
Holidays.
Yep, we're going to talk about commission rebates under the licensing rules, and some other things as related to the commission lawsuits and how rebates and stuff are looked at now.
Wonderful. Cool. Awesome. Well, thank you guys so much for your time, and we'll see you the next go round.